Okay, good morning, everybody, and welcome to our SSDN webinar on copyright for digital libraries. We have a lot to cover today, so I am going to go ahead and get started. Just a little bit of housekeeping. If you have any questions, please feel free to put those in the chat at any time, and I will get to them as I can. You will not be able to unmute yourself during the meeting. But if you would like closed captioning, we have enabled that. Just hit the CC button or the transcript button that's located at the bottom of your Zoom window. You can also use that button to turn off the closed captioning if you do not want to see that. Please be aware that there may be errors because it is automated. And today's meeting is being recorded as well. Also, I'm Kayla. I am the Sunshine State Digital Network coordinator, and I will be doing today's training for everybody. Okay, so to start off, as a disclaimer, I am not a lawyer. I am a cultural heritage professional, and what you will be learning today is not legal advice. It's a set of strategies for content selection for digitizing your special or archival collections. We will be dealing with the law today, so things can be interpretable and squishy, and there are very few absolutes when it comes to assessing copyright. There will be a lot of nuance involved in assessing copyright status. Additionally, I also want to note that we will only be covering US copyright law during this presentation. Items created and published outside of the United States are subject to different laws and regulations. It's just something to keep in mind for today's presentation. Okay, so our goals today are to make sure that you're able to assess the copyright status of an item, be able to identify content for digitization based on its copyright status, and being able to create useful rights and access metadata for users and for yourself. Okay. So let's start with what is copyright. So when we talk about rights, we're talking about any reproduction or publication restrictions on an item. So it's copyright status according to US law. In the world of digitization, we're in the business of making digital copies of physical items, and this is considered reproduction. We're also in the business of display, which is a kind of publishing. So, history of copyright law is about balancing the protection of creators with the public interest in access. Copyright terms change, and this is the amount of time that an item is protected when it is released to the public. So as we talk about some of the ins and outs of current copyright law, you'll see that we're often talking about different time periods or periods of time. The length of those periods of protection for copyright owners have also changed over time, especially gets very strange in the middle of the 20th century, as we'll learn today. And copyright law changes over time. So that means that it's important to refresh your own knowledge of copyright from time to time. Copyright law is also designed to give you the most protection to the unpublished creative works of artists and other creators. So why is copyright important? It helps cultural heritage institutions determine whether or not they should digitize an item, and if they decide to digitize, what level of risk they are accepting. So I'll talk a little bit later about what risk means in this context. And I know that it's a source of anxiety for a lot of institutions. Copyright isn't just important for digitizers, it's also very important for the users of digital content. So knowing the copyright status of an item helps users determine what they can and cannot do with it. Can they make their own copy? Can they add things to that copy? It's really important for you to share what you know with them so that they can use your content responsibly. Now we're going to talk about how to evaluate your content as you're selecting for digitization. I'm also going to make some practical recommendations about how to get started. So we're going to start with these 5 questions. These are questions that should be considered with every single item that you're assessing. So do you know who the creators are? When was this created? Was this ever published? And published here means something broader in the context of copyright law than it may mean in the way we think of it. So we'll talk about that as well in a minute. So was it published, and if so, by whom? Do you have external information about copyright restrictions? And can you contact the donor to find out what, if any, copyright restrictions may apply? So we'll start with a deed of gift. A deed of gift is a signed document that voluntarily and without recompense transfers ownership of real, personal, or intellectual property, such as a gift of materials, from one person or institution to another. It should include any possible conditions specifying access, use, preservation, and more of the gift that is being received or given. Although these are generally discouraged by recipient institutions. So a note about best practices for collecting new archival materials. When you receive a donation, be sure to ask questions upfront from donors about digitization and online display, and get the donor to make an agreement with you about what is and is not okay online during the donation process, instead of trying to find donors at a later date. So this is a best practice from now going forward, if you don't already have something like this in place. I know we don't have the luxury of this many times for our historical materials that we've received in the past. You may have deeds of gift that did not take digitization or online display into consideration because those were not possible when the gift was received. So that's okay. It's just something to consider going forward. So what can this look like in a deed of gift? So here are 2 examples of potential language that you can include in a deed of gift that take this into consideration. One is that the donor or the owner of the intellectual property allows you to present the materials online for scholarly and educational purposes, but retains the copyright. And the other is an example of when a donor is also passing the copyright to the organization that they're donating the items to. Please keep in mind that this only applies if the donor actually owns the copyright to the material. Sometimes people are donating items that don't belong to them or were not created by them, or they do belong to them but were not created by them, and they thus cannot transfer copyright to anyone because they do not hold the copyright themselves. Okay, so as you begin your content selection process for digitization, you want to start by identifying content that's in the public domain. This is going to be content that you won't have to worry about the copyright status of because it is freely available. So what is the public domain? This is when the intellectual property rights of works have expired, have been forfeited, or are inapplicable. So this is when copyright law does not apply to a work. It is no longer protected by copyright. Works in the public domain may be used freely without permission or attribution. This is a really important concept to understand about materials in the public domain. This coin has 2 sides. So you can digitize away, and you shouldn't be concerned about risk when digitizing materials you can identify as in the public domain. But this also means that your digitization is a public service. And once you put public domain items online, users do not have to ask your permission or attribute the content to your institution. It's considered a good practice to attribute public domain materials, but be aware that this is not required. Okay, so these are 5 common ways that works enter the public domain, and we're going to walk through each of these 5 situations one by one, so you feel comfortable with the process of identifying public content. So we'll start with the copyright has expired. So remember that I said published materials means something specific and a little different than we are used to in the context of copyright. So any item that was published in or before 1926 are in the public domain. Luckily for us, as of 2019, there is a rolling date for copyright of materials entering the public domain. So next year, items published in 1927 will enter the public domain. As of this year, 1926, and before are now in the public domain. So let's define what published means according to copyright law. Publication means distributed to the public. So we generally think of publications as applying to items with publishers, like books, journals, or newspapers. But published, according to copyright law, is a lot broader. It means that anything that is distributed to the public is considered published. So this could be a pamphlet or art, a playbill or something like that that is produced, not necessarily published through a traditional publisher or disseminated broadly to the public, but is distributed in some form. Some examples of things that are published versus potentially unpublished materials are here on this slide. So items like posters and brochures that are distributed to the public are considered published, and unpublished materials include items like private correspondence and most photographs. So take this, this again has some nuance because postcards would have a double layer of copyright protection. So the image on the back of a postcard would have its own copyright protection, but then the correspondence, if it is a postcard that was sent in the mail, has another layer of protection of the person who wrote and sent that postcard or sent that correspondence. So that's something that you want to take into consideration as well, is whether something may or may not have multiple layers of copyright protections. Other examples of that would be video and audio, which are even more complicated than printed material and photographs. So that's something to keep in mind as well. And again, copyright law is designed to offer the most protection to unpublished materials, especially creative materials. So if we look at the top row of this chart in particular, unpublished materials, like the correspondence we discussed earlier, gets a longer term of protection. The life of the author plus 70 years. That means that you add 70 years to the year of the creator passed away. And then, and only then, does the item fall into the public domain. And if you don't know who the author is, it's 120 years from the date of creation. So the second situation where an item can go into the public domain is when the copyright owner has published the work without a copyright notice. So remember earlier that I mentioned that copyright law changes during different periods of time. So for a period of time in the 20th century, copyright owners were required to put a copyright notice on a published work to claim copyright. There are nuances again to this, but the key window of time here is 1927 to 1977. So if you have an item published between 1927 and 1977, check it for a notice. If it doesn't have one, it's now in the public, it's considered in the public domain. As a note, copyright notices generally have the word copyright or the copyright symbol followed by the name of the copyright holder. So here's an example of an ad from 1938, which is between 1927 and 1977. And in this instance, this ad does not have a copyright notice printed on it. So this would be considered in the public domain. The third instance that an item can enter the public domain is if the copyright owner has failed to renew copyright status of a published work. And again, this is, one of those instances where it's a period of time. So copyright renewal requirements tripped up a lot of copyright owners before the current copyright law did away with them. So failure to renew caused many works originally published from 1927 through 1963 to enter the public domain. You can pursue these, but it requires some research with the US Copyright Office. And I've included a link on this slide to UPenn's database on copyright logs for renewal that you can search through. It also links to the Library of Congress database that goes through 1978 for copyright renewals. Some additional information on this is that the 1909 Act, the governing law for most of these works, provided for 2 copyright terms. So an initial 28-year term and a 28-year renewal term. But the copyright owner didn't get the second term unless he or she filed a renewal application with the Copyright Office. If the renewal application wasn't filed on time before the 28th year expired, the work entered the public domain. When the 1976 Copyright Act was passed, Congress added 19 years to the renewal term, bringing it from 28 years to 47 years, for a total of 75 years. Copyrights already in their renewal term got the extra 19 years automatically. Copyrights in their initial 28-year term on December 31st, 1977, got the 47-year renewal term as long as the copyrights were renewed in their 28th year. So again, this is going to be really complex, and you are going to have to do some research in those renewal logs to make sure to check whether or not the copyright holder renewed their term. So the fourth instance where an object or intellectual property enters the public domain is if the copyright holder deliberately places or dedicates the work to the public domain using Creative Commons zero dedication. So this is a license that through the Creative Commons that allows the copyright holder to place it in the public domain upon publication. So this is either known as a CC0 license or a public domain declaration. You can use either of those terms. And we will talk about Creative Commons later on in this presentation as well. So this is an example of an item with a CC0 license. You can see it here, public domain CC0. It's really common to see this on like photo sharing sites and things like that. It's not generally common to see this on content from cultural heritage institutions because most of the time it's material that was created before Creative Commons existed. And additionally, only the copyright holder can add a Creative Commons designation to something. It can't be something that can be done by the library or organization that's digitizing the content. So this again is an example of where a photographer has given this object a Creative Commons designation. This is very common in scholarly works nowadays. So if you're also curating scholarly works, this is something to take into consideration as well. And in the last instance that we're going to talk about today about how an object can enter the public domain is if copyright law does not protect this particular type of work, is not subject to copyright protection. The most common way an item enters the public domain in this fashion is if it's produced by the federal government, its employees, or its employees as part of their jobs. And this is also applicable to some state state documents as well. Different states have different policies, but in the state of Florida, anything that is created by any state, regional, county, district, or municipal government entity, it does enter the public domain upon creation. So anything created by a state government or local government in the state of Florida does enter the public domain automatically. But a caveat on that is that not state universities are considered a different designation, not necessarily government. So state universities do retain copyright for materials that they create. So that's something to keep in mind. An institution should not claim copyright on digitized content when the original is in the public domain. So this is an important point about rights. And you see a lot of folks claiming digital copyright over digital reproductions that they've made of physical items. But the goal of most digitization is to create a copy. And according to copyright law, you need to be creating an alteration that meets standards for originality and creativity. So this is the difference between creating a new work and slapping something on a copier or a scanner. A good example of this would be the artist who put a mustache on the Mona Lisa. Obviously, the Mona Lisa was considered a public domain work because of its age, and a digital copy of the Mona Lisa painting should also be labeled as in the public domain. But the mustache that the artist put on her was a commentary on art and Mona Lisa's masculinity. So it gave the artwork a new creative message, and it was therefore entitled to copyright protection, even though it was originally an alteration from a public domain work. So that change made it copyrightable. And in most cases, we're not making alterations to the content or any meaningful alterations. If we're doing color corrections or anything like that, doesn't count because it doesn't really change the meaning or the message of the content itself. So a quick recap is if we're assessing a piece of content and it fits into any of these 5 categories, you are free to digitize and make available as you please. The content is considered in the public domain, and therefore its digitization poses no risk to your institution. So we're going to very quickly go through an example with everybody. So feel free to answer these questions on the slide in the chat box. So was this published? Do we consider this to be published content? Yes. Yes, that is correct. It was distributed. So it is considered published under copyright law. And do we know if this is considered in the public domain? So to help clarify a little bit, that language that we see at the bottom, that's what it says down there. For anyone who can't read it because it's very small. So this is not a copyright notice. It was published in 1950, which was within that time period where a notice needed to be on the publication. So this is not protected by copyright. It is in the public domain. Okay, here's another example. This is a letter sent in 1833. Would this be considered published material? No, that is correct. This is private correspondence, so it is not considered published. Do you remember the copyright term for unpublished material? 70 years plus the life of the author. That is correct. So if we know the death date of the author, which if this were in your collection, you might know that. So we know that Sophia Hawthorne died in the 1870s. So it has been more than 70 years since her death. If we didn't know her death date, we know that it has been at least 120 years since this was created. Um, so it is in the public domain regardless of whether we knew the author's death date. So this is also in the public domain. Okay. Would we consider this pamphlet published material? Yes. And is it in the public domain based on its publication date? Yes. Correct. So this was published before 1927, so it is in the public domain. Okay. Do we consider this to be published? And is it in the public domain? Yes, because it is a work produced by an employee of the federal government as part of their duties. So this automatically went into the public domain upon its creation. Well, this was he produced it as part of his job, so it did go into the public domain. But that's a good question to consider when you get a donation: is what is personal and what is considered what was produced as a part of someone's duties. So that's a good question to consider. And if the person who's donating the items is the person who created them, it's a good question to ask as you're taking the donation. Okay, and this is our last example for this section. So this is a menu. Do we consider menus to be published material under copyright law? Yes, we do. They are distributed. Okay, so what do we need to look for on this item to determine whether or not it is in the public domain or protected by copyright? A copyright notice, correct. And what it says down here is not a copyright notice. It says waste receptacles are provided in convenient locations at each end of the car, as well as in the center portion. Your cooperation is in this regard will be appreciated. So that is not, in fact, a copyright notice. And so this item is considered in the public domain. What is in the bottom right is a number 4-1-4. So that again is not a copyright statement. If it had been the C in the circle, which is the copyright symbol, then yes, it would be, but it is not. Okay. So what do we do if an item is not in the public domain, which would be much of the material that we would have collected during the 20th century does not automatically fall under this category. So let's talk about our options there. So the first thing you want to do is wait before you go and digitize it. If an item is not in the public domain, you have some options to pursue. The first of these is that you could wait to digitize it. For items published before 1927, again, you're safe to proceed. For items published between 1927 and 1963, you'll need to spend some time investigating on a case-by-case basis, but chances are good that you will find them in the public domain. And again, this is because many people did not renew their copyright during this period of time. Yes, Jay, that is correct. It did trip a lot of people up. So there are a lot of items within this time period that are in the public domain because they did not get renewed. And just as a reminder again, as of 2019, we have rolling copyright dates. So items enter the public domain on an annual basis. Okay, so the first thing that you want to do, if you determine that an item is still protected by copyright, is to get permission from the copyright holder, um, and try to identify the copyright holder. So you need to be able to document this process to show due diligence. Um, and due diligence is not a defined concept, um, but basically you want to exhaust all reasonable options for locating a copyright holder and document this process thoroughly. So you can do this as simply as like this chart illustrates, or you can have more thorough documentation if you'd like, but you do need to document the process and whether or not the copyright holder has been located and if they have given their permission for you to digitize and place the items online. So let's say you've tried to locate the copyright holder, you're not able to identify who the author is or who the publisher is. This would be considered an orphan work. So for older materials like photographs and audio recordings, it may be impossible to identify who the copyright holder is, particularly for, I know that a lot of us get like a box of photos dropped off. The person taking the donation did not get a deed of gift signed or something like that. It's pretty common. And we don't know who took the photos. Very often, people who have the photos were not necessarily the people who took the photos. And a lot of people have photos of themselves, and they usually don't take those pictures of themselves. So they're not the copyright holder either. So what can you do with orphan works? You can digitize these objects at your institution's discretion. So you want to consider your institution's risk and comfort level. And lots and lots of institutions do end up digitizing orphan works, but some err on the side of caution here. And again, we'll talk about risk and risk assessment during this presentation as well, but it's something that your institution should determine a policy on. Whether or not you want to digitize orphan works. So Sam asked in the chat, for orphan works, should you put a disclaimer statement? For example, after due diligence, we believe this item to be an orphan work. If we are in error, please let us know. Yes, you can do that. There is, when we talk about standardized right statements, there are standardized right statements that also are to this effect, that basically state that you are unable to locate the copyright holder or unable to identify the copyright holder, but you believe it to be either in or out of copyright. So that is something that you can do. Institutions also can have takedown notices to that effect for their site in general, that they believe that they have done their due diligence in obtaining copyright permissions. Joy, thank you so much for putting the link to the standardized right statements, rightstatements.org site in the chat. That is also a resource we'll talk about later as well. But takedown statements and disclaimer statements on the record are a good way to express the due diligence that you've done in trying to identify the copyright holder. So we'll talk a little bit about fair use as well. So libraries have a lot of room to make fair use cases for digitizing and making publicly accessible items protected by copyright. So use cases to emphasize that fair use is a set of guidelines that gets tested in court, where its boundaries are drawn on a case-by-case basis with implications for other institutions. Fair use is not law, so it is more squishy. It's a set of guidelines. Yes, and commercial works can still be fair use. It's a lot squishier than copyright law because copyright law just says whether or not the rights holder retains the rights to the item. Fair use is whether or not you can share that item for specific purposes. So commercial works can be considered under fair use depending on what they're being used for. So it is a lot squishier than copyright law. So under fair use, if the purpose is for nonprofit or it's a transformative work, it's factual in nature, and you're not using the entire work, it doesn't hurt the market for the original, that is considered fair use. It's not fair use if you're using it for commercial practices for the most part. We do talk about an example, a fair use case where that the court ruled in favor of the person using the item for commercial purposes. Well, also, and yeah, there's a lot of fair use is a lot more complicated. But we have, as libraries and institutions of higher education, there is a lot more cases to be made that we're using items in that fashion. So this is the first case we're going to talk about. And again, this was a commercial use of some photographs. So a photographer sued an image search engine over use of her thumbnail images, and the photographer lost this case. And the reason that she lost this case was because the court determined that the use of the thumbnails for the search engine did not affect the market for her original photographs, because they were only using thumbnails and not the full image size. So they considered that to be transformative, even though it was being used for commercial purposes. So that is an example of a commercial use that was considered fair use. This one is something we're very familiar with. I would think as librarians, there was a case where Google sued because of the use of because of the scanning of books. Well, I'm sorry, Google didn't sue, the publishers sued. And the reason that this was considered fair use is because it was being used for preservation of the text, and it was also being used for accessibility reasons for disabled patrons. So these were considered transformative in nature. So the court ruled in favor of Google and the libraries for digitizing these works in full. So the Authors Guild lost this case because they claimed that it infringed on the market value in the market of their work, but the court did not see it that way. So if you're digitizing full like books, for example, and you're doing it because the original copy that you have is at risk of falling apart or something like that, and you're not able to get more copies because it's out of print or something like that, that would be considered transformative and a fair use case for that particular digitization. So a quick recap on usage considerations and fair use. You can wait until an item is clearly in the public domain, which may take a long time. You can get permission, but again, if you are unable to locate the copyright holder, that is considered an orphan work, and that is up to your discretion whether or not you'd like to digitize that. And then you want to consider fair use of the objects. So we can do a risk assessment to determine whether or not our institution would like to take the risk of putting up orphan works or digitizing other items that may be protected by copyright. Most cultural heritage organizations have never encountered problems in terms of this. You usually don't get sued right away. Um, there are some institutions that are going to be more risk averse than others. So it's an important conversation to have. If you have legal counsel, to talk to them about that. If you do not have legal counsel to develop policies that you can point to, and also workflows to determine the best course of action for certain things. So no matter what you personally think about the risk you're willing to take against challenges to fair use or to Section 108 implementation, it's important to also consider what level of risk the institution is willing to support. So some publishers, for instance, are uncomfortable with any assertion of fair use rights as they wish to avoid lawsuits at all costs. Many libraries, however, are less risk averse, in part because of the generous provisions of Section 108 of the Copyright Act and the fact that there is very little litigation about these sections of the Act, and because librarians in particular are protected from statutory damages in fair use cases if their fair use assessment was reasonable and made in good faith. For instance, Section 504C of the Copyright Act provides that the court shall remit statutory damages in any case where an infringer believed and had reasonable grounds for believing that his or her use of the copyrighted work was a fair use under Section 107. If the infringer was an employee or agent of a nonprofit educational institution, library, or archives acting within the scope of his or her employment, who or such institution, library, or archives itself, which infringed upon reproducing the work in copies. So note that in order to document this type of good faith practice, librarians should not engage in large-scale digitization of in-copyright materials without engaging in careful Section 108 and fair use analysis item per item. Not to mention that the fact that state institutions may also claim sovereign immunity from suit. So in other words, the best case scenario for an entity suing a public library for a fair use or Section 108 violation could be to obtain an injunction, but it's not necessarily going to have financial implications. Nonetheless, it's important to understand the level of risk your institution is willing to bear and keep that in mind when conducting a risk assessment. So we're going to talk about what could potentially happen if you decide to digitize something that's protected by copyright and you post it online. You could get a takedown notice, and a copyright owner should provide official notice to the host that houses the infringing material first. So the first thing that you'll get is a takedown notice, not a lawsuit. And it will say that you must act expeditiously to remove or disable access to the alleged infringing material. So something to denote here in legal language is that a notice is legal and a request is not. So a takedown notice is going to be an official legal document, and someone just sending you a request to take something down is not considered a legal action. So when you get a takedown request, which again is not a legal action, you need to consider the legitimacy of the request and either take down the offending item or don't. So again, a request can be, you can decide that you want to disregard the request, but if you do get a legal a takedown notice, that is a legal document and you should take the item down. Some examples of how often institutions receive these is HathiTrust, as we know, has thousands of books online, and they generally get 10 or less takedown notices since they were created. And the New York Public Library, which has a high risk tolerance, generally gets about 10 every year. They're often invalid and they don't usually take materials down. So again, it just depends on your institution's approach to risk and whether or not you want to deal with this. But generally, you're not going to. Most institutions are not going to get them. These are both very high profile institutions. They get used a lot. Um, so it's up to you where you feel your risk lies. So, when appropriate, you should try to push the envelope. Um, if we're not looking out for the needs of our patrons, who will, right? So, um, we're trying to provide as much access as we can for the public good. So, just keep that in mind as well when you're having these conversations. And again, you want to think about the likely source of pushback. So if you have a lot of content related to public figures or produced by famous people, the risk for those materials is going to be higher. You also want to consider privacy considerations when making these decisions. Again, those are not copyright considerations, but it is something else that you might want to consider when selecting material for digitization. Okay, so we've determined the right status of our work and we've decided to digitize it. So now we want to clearly and concisely state the copyright status in the material again, so that not only us, but our users know what they can do with that material. So based on the copyright statement provided for this object, do we know what we can do with it? Has that been communicated in this rights statement? Yes. Um, so this rights statement gives contact information, but it does not actually give any information on the actual copyright status or the reuse of this for the reuse of this item. It creates a situation where someone has to man a permissions desk and or field questions even for items that are in the public domain. So if you have a statement like this, you're putting yourself in a position where people have to contact you, um, and it may not always be necessary for you to have to field those kinds of questions, because a lot of material is going to be in the public domain. Um, so this adds work rather than make it clear what people can do with this. How about this one? Yes. So this one is not as open. It clearly states that this object is under copyright, but it is a lot clearer to the user what they can and can't do with this and who they should contact. So the fact that St. Cloud State University Archives negotiated to digitize a single copy of this work is still a public good, even if it can't be reused without permission. So this is a much more clear statement. So you want to consider that when forming your statements for your metadata. What about this one? Yes, this is in the Creative Commons. So this is a self-portrait of photographer Leslie Jones. Here you can clearly see that Leslie Jones does still hold the copyright to this image, but there is a Creative Commons license that tells us that we can what we can and can't do with the item. So we don't have to contact anyone to know. In this case, according to this Creative Commons license, we can use this item non-commercially as long as we attribute it to Leslie Jones and we don't make any derivatives. So this item has the two important pieces of information that should go in a rights field: the actual rights copyright status of this and the access statements for how they can be used. Why is the created date so long? They probably used a date range for the collection of when he was producing this particular work. We don't always know the exact date when something was, so date ranges are common when you get like a big stack of things. Okay, so a right statement communicates the legal status of an item, and a reuse statement communicates how to responsibly use an item. So that's the distinction there. Best practice in this case is to include reuse statements with right statements whenever possible, and repeat the field for each statement. So in your system, if you are able to repeat your rights field, you want to be sure that you include it separately from each other. Um, and you want to make sure that your users understand what they can and what they can do with content on and offline. A good way to do this is by using standardized right statements. A project in collaboration between DPLA and Europeana created rightstatements.org, where there are 12 um, statements that clearly communicate the rights status of an item to users. These were created specifically for cultural heritage institutions to cover the most common situations that they encounter in terms of copyright status. They're simple and flexible and very clear. They only describe the copyright status, so they don't have other legal restrictions like privacy or reuse considerations, but it is a simple way to communicate what the right status of that object is. Additionally, it's also human and machine readable, so it's interoperable across systems because it uses a URI. We created this because in a survey of DPLA data of 1.3 million records, DPLA has over 40 million items in it, so this is a very small sample of records. There were over 26,000 unique right statements, and they communicate a lot of different things. Like we saw, one just had contact information, one clearly had a copyright statement in addition to contact information, another one had a copyright statement and a reuse statement. They're all very different. It's difficult to sort through that, and so this just makes it easier to determine that. So here are some examples of some of those unique copyright statements. This one is really, really long. It provides a lot of general information about copyright, and it's not really relevant to this particular image. And in addition to this copyright statement being really, really long, you can see that this item says it's copyright to Brigham Young University. This is actually incorrect. If you look at the creation date, this object is in the public domain. So this is an example of where they may have just put this copyright statement on all of their objects in their library, in their digital library, but it is actually incorrect in this instance. This one's a lot shorter than the one that we just saw. It's a lot briefer, but you'll notice that it doesn't actually say anything about the copyright status of this item. It just says that the item can't be reproduced without getting permission from this institution. Permission to publish is different from copyright status, and the rights field really isn't the best place for publication information. So in addition to this statement, you would want to let the user know what the copyright status of this would be. This right statement just says Smithsonian American Art Museum, museum purchase. That is not a right statement at all. It's provenance information. So the contributing institution field up towards the top of the record already says where this object came from. So this is repetitive and doesn't belong in this field, and doesn't communicate that right statement to anyone. This one's a little bit longer. This one also indicates the item is still in copyright, but then it goes on to provide lots of information about how to get permission to use the image. This is helpful information, but it doesn't necessarily belong here. And then this is an example of a simplified and straightforward right statement that is easy for users to understand. It simply says that the item is in the public domain and that there are no restrictions on use for this item, which is nice and easy and simple, but makes it difficult to sort or search for items like this if everyone is using different language, right? And this is the last example. This is similar to what we talked about earlier, where it's kind of a disclaimer statement. This organization has made the item available, believes that this item is in the public domain, but a determination was not made as to its copyright status on the copyright law of other countries. So again, it provides useful information. This image is from the 1600s and is in the public domain in the US. So to make it easy for users, it also contains a URI that I kind of blocked with this line, but you can see that it does use their standardized rights statement, which says no copyright in the United States. When shared to an aggregator like DPLA, they can use that URI to then make a clear designation to the user that this does not have copyright protections in the United States. So these are the 12 statements created by the Standardized Rights Statement Project, rightstatements.org. These are the 6 that you will probably find most useful for your collections. And then this is what they look like on rightstatements.org. If somebody clicks on that URI, it takes them to this, provides more information about what that status means. Additionally, if you use the standardized rights statements, you can also use it to help filter content. This makes it easier for users to search for content that is easily reusable for specific contexts. Yes, they do put it at the top of the page. That's an old screenshot from a previous DPLA platform. So it is at the top of the page now rather than at the side. Okay, so Creative Commons, again, is a license for how users can use the work. It can only be added by the creator and not by the library. And these Creative Commons licenses do work internationally. So that's something else to consider if you're collecting more modern material. And I'm going to go a little bit faster now. These are the Creative Commons designations. We're almost out of time, and I want to let you all ask questions. And then this is what they look like if users want to add them to their work. This goes from most open to least open Creative Commons licenses. And the Creative Commons site does provide URIs as well as additional information for what each designation means. So here's an example of a Creative Commons license in practice. This license tells us what we can do with this image, use it non-commercially if we attribute it, and any derivatives that have the same license and aren't made less open. So Creative Commons attribution, non-commercial, share alike. This is an example of a Creative Commons license where users can use it non-commercially if they attribute and don't make any derivatives. So a quick recap, there's no right way to assess copyright and implement standardized rights statements. Every process is going to be a bit different and based on your digital content and the systems that you're using and the resources that you have available. So first, you need to consider risk assessment. What's your institution's risk tolerance? Then you need to know your current rights landscape for existing digital collections. Does your digital content already have rights information at the item level? If so, what does it look like? If not, is rights information documented somewhere else? And are there folks that you can talk to who have background information about copyright for those materials? Once you know what you're working with, you can develop a plan and you can determine who's going to do what work and how much time they can devote to that project. So you can see that there might be training that might be needed, and then you can start thinking through workflows and how you might address questions that come up, including any documentation that you're going to keep. Depending on the number of items that you have to review and the amount of time that you have, you may not have the time to do all of the in-depth research to figure out what the status of every item in a digital collection. So if you're working on legacy digital content, it can be really helpful to review your metadata for useful information like the date of publication or the death date for the creator for unpublished materials. For archival materials, it's also helpful to check the deeds of gift for rights information. Um, and then one thing you want to make sure is to document your decisions and the rationale behind your decisions. Once you evaluate your digital content and determine the appropriate rights statement for each item, you want to include the rights information in your metadata. Workflows here can vary a lot depending on your system, but in many cases, I think you'll find that spreadsheets are your friend and that you can find and sort it by date and creator to group similar items together and document your decisions and questions. Okay. So does anyone have any questions? That's a lot of information. It's okay if you don't have any questions at this time. If you have any questions as you're doing your assessments, please do feel free to reach out to the Sunshine State Digital Network with any of those questions. DPLA also has a rights statements group that has put out some really great resources. Yes, this recording will be made available later. So you can consult those resources as well and pose those questions to the group to see if they can help either point you to resources or help you walk through some of that assessment. Yes, so the presentation will be sent to everyone who registered as well as be made available in the description of the recording. So that will all be there. Okay, so I guess thank you everybody for coming today, and please feel free to reach out if you have any questions. Thank you so much.